We do not have him, but I believe, let's see, one, two, three, four, five. We go five. So we have five members, so that should give us the quorum that we need of the members that were present for the initial public hearing on this item.
Okay.
So, Mr. Chairman, when you're ready, just let Craig know, give him a half a second to get the recording started, and then we can proceed.
Okay. I think I saw a message that it was started, but go ahead. We're ready. All right. All right. This is an October 28, 2024 special meeting of the City of Charleston Board of Zoning Appeals Zoning. And present, I'm going to need Mr. Summerfield's help on this to see all the people who are present at the meeting. I know that Allie Grass is here, Robin Richards, Howell Morrison, and I'm not sure who else from the membership.
John Bennett.
Okay, John Bennett is here. Thank you. Anybody else that I missed? All right,
No.
so I think we're missing Mr. Goodwin and Mr. McKay. Is that right?
Yes, sir.
And then present from the planning staff, we have Mr. Summerfield, Mr. Bennett, Craig Bennett. Who else do we have from the city?
We have Miss Allison Craig, and as a special observer, we have Miss Penny Ashby, who is supposed to be resting, getting ready for her surgery tomorrow, but she wanted to observe tonight's discussion.
Can't keep a good lady down. Well, we're glad and fortunate to have her online here. So we'll conduct this meeting in the usual fashion. We'll first receive information from city staff about the application and the recommendation. In this case, it's an appeal, of course. If the recommendation is favorable and no one objects to the application, the matter is uncontested. The Board of Zoning Appeals usually, but not always, approves uncontested applications. For all applications, the board reserves the right to ask questions of the staff, applicant, or others in attendance prior to rendering a decision. If, however, the city recommends against the application or if there is opposition to the application, we treat the application as contested and hear from the applicant and anyone else who is in favor of the application. Next, we hear from anyone opposed, followed by a short rebuttal from the applicant. We then close the public hearing portion of the meeting for that particular application and open discussion to the Board of Zoning Appeals members only. We will then make a decision to approve with conditions, or deny the application. The Board of Zoning Appeals Zoning has the authority to do three things. Number one, hear appeals to decisions of the zoning administrator. Number two, grant special exceptions, a fact-finding function of the board. And number three, grant variances to the zoning ordinance if the application meets the hardship test outlined in section 54-924 of the ordinance. Board may deliberate and make a final decision on a matter by a majority vote of members present at the hearing and qualified to vote, provided that not less than a quorum is present and qualified to vote. However, an affirmative vote of 2/3 of the board members present and voting shall be required before a use variance to be granted. And then we have variance elements that I won't go over because this is an appeal of a zoning administrator decision. And so I think it's sort of difficult to try to swear people under oath during this proceeding. I do ask that if you do intend to speak today, and I know we have a list of people, that you'll tell the truth. So, Mr. Summerfield, I'll go ahead and turn it over to you. We have a review of deferred applications from previously advertised BZA-Z agendas. Number one is 1142 Lining Court, Farmfield, Council District 11, TMS number 349-11-00-104, zoned SR1, requesting reconsideration of the zoning administrator's decision to approve a residential STR permit application for this property. The owner is Mariah Hogan, and the applicant or the person who filed the appeal is Jimmy Bailey. And so, Robert, you can bring us up to speed.
Yes, sir. And I apologize. I'm remiss. We have two additional city staff members on this call as well. One is Christina Walsh, who without her work to get this scheduled, this would still be hanging out there. So very much appreciate Christina getting that done. And then legal counsel for the city, Magley Creech is on. I know there was a question when we were scheduling this about whether or not there'd be an executive session. There was not one pre-scheduled, but should the members of the board determine that they need to speak with legal counsel in an executive session, we would need to appropriately amend the agenda, and then Ms. Creech is available in either executive session or not to provide additional feedback to the board on this item. So as you all are aware, this item came before the Board of Zoning Appeals previously. It has had its public hearing, and it was voted for a deferral during board discussion to allow, or deliberations to allow for some additional information to be provided to the board. Ms. Ashby has provided that information to the board. I think it's been several weeks ago now, so that hopefully everyone's had an opportunity to review that additional material. Just to reorient everybody, so this is regarding the approval of a short-term rental permit on this property at 1142 Lining Court, as seen here in the Fairfields neighborhood. Just the aerial of where this property is, a decently sized lot in a pretty well-established residential neighborhood. Staff provided, again, slides that just showed the application that was submitted with the information, the approval decision by the zoning administrator from back in July. And we have obviously this email because this has been a lot of back and forth with legal. The appellant also provided quite a bit of information as a part of the backup material for their appeal, including some pictures of the completed addition to the property. And again, they reiterated the application. They provided some information from what was submitted to the county, some questions that they had regarding parking and how that works with the floor plans, and then another copy of that. They also provided information on the community. It's an older community that had, well, not that old, but that has some older CCNRs that go along with it. There were some questions about whether or not a short-term rental could be possible there. Again, our legal office weighed in that while the CCNRs speak to a number of things, they do not speak to short-term rentals. Understandably, short-term rentals as a concept is somewhat newer, and so a lot of older CCNRs do not address it unless the HOA has taken up that issue and gone back and redone their CCNRs in more in the last decade or so. Excuse me. Then we had correspondence from the appellant as well as some other neighbors. There was a petition about the fact that a number of folks are not thrilled in this neighborhood about the short-term rental application. They provided some additional copies of some mapping. The owner of the property also supplied some slides that were in here, as including the CCNRs again. Again, all of this is available. I can go to any page if you need to. They provided some additional mapping. There's a couple things that have been asked as questions that I want to just, and I'll go all the way to the back here. That have been brought up related to this. One, at the time application was made for the addition, staff's understanding is that the reason that they marked that this is not for an STR is because at that time that was not the intent of the addition. The intent of the addition was to provide additional living space in the home for the daughter who has, and I apologize, Mr. Henry, I don't know what your client's disability is, but she has some disability. The addition was to provide some additional living space to accommodate her to kind of live somewhat independently within the home. Subsequent to that, their thinking changed, other stuff changed, and that's why they made application for the STR. Unfortunately, our ordinance doesn't create any kind of date from when someone says they're not doing an STR till they've changed their mind and now they want to do an STR. It's one of the conversation points we're having for the zoning rewrite, but as of now, our code doesn't. You're allowed to change your mind. So that is why staff did approve the STR, obviously knowing that there had been a recent addition to the home. And then I think there was a question about the ownership requirement. Again, it's our understanding that the daughter is now a part of the ownership of record for the property, will be residing at the home, and therefore is satisfying the owner occupancy component. So I think those were two recent kind of clarifications that we were asked about. I did want to put those out there. Obviously, this is an appeal of the zoning administrator's decision to approve the short-term rental permit, and staff is asking the board to uphold that zoning administrator determination. So with that, Mr. Chairman, I would turn it back over to the board.
All right, since this is an appeal of a zoning administrator decision, we did hear from the appellant and those who supported the appeal during our initial meeting on this, and we, at the conclusion of that meeting, requested additional information. I'll also note that we did hear from the owner and people in support of the owner at that meeting as well. But we'll go ahead and do the same thing. Mr. Bailey, I know you're the appellant, and so I think it's appropriate to hear from you first. Just keep in mind that we did, hear, I think, a pretty full explanation of your position at the first meeting. So, but we'd be happy to hear from you first.
No, and Mr. Chairman, I'll start the way I started the last time, to thank you and the board members for your commitment to the community. I've been there and I understand what you have to do, and I thank you very much. Having said that, I go back to the original information that I shared with you. The property is owned single-family residential. And I've sent you emails from Lee to me and vice versa that it was a mistake to approve the addition. And unfortunately for the applicant, and unfortunately for 100% of the neighbors, short-term rental just doesn't work in this neighborhood. Mr. Chairman, I also remember you asking me about Ruthie Ravenel's property. And so I went back and looked at that. That property is 0.92 acres. And the request to your board was to allow an addition for a mother-in-law or what have you. The subject property in question today appears to be about 8,000 square feet. So there's a big difference between why you approved 0.92 acres and this. And in addition, I reminded the board that you unanimously voted against short-term rental on that property. It was allowed to have a rental unit. Now, going back to, there's nothing more that I can add today other than to say the planning department made a very, very serious error and given the permit from the beginning. Lee Batchel admits that in the information that I've given you. And if you review all those emails back and forth, what Lee was saying is it had to be one family living in the whole house. That was, that's what SR1 means. And to come back and after the addition is made, think about the can of worms that would be open if everybody said, well, we just want to add an addition to our house, and then come back a year later and say, well, by the way, we've decided we want a short-term rental. So I hope that logic prevails. I hope that 100% of the neighbors who have objected, I hope that prevails. And I'm sorry it got this far. It should not have gotten this far. And I am very sorry for that, for the board, for the city, and for the applicant. So with that, I hope that the fact remains that the ordinance does not allow an addition to be made to be used as short-term rental. And with that, I will be happy to answer any questions.
All right, thank you, Mr. Bailey. Does anybody have any? Well, instead of asking Mr. Bailey questions right now, why don't we go ahead and see who else is present to speak in favor of the appeal? Is there anybody else who wishes to speak in support of Mr. Bailey's appeal? Robert, did we have anybody sign up to speak on behalf of the appellant or in support of the appellant, or is Mr. Bailey the only one here?
So because we didn't have the normal sign up sheet, I'm not sure. Christina from bless you, from what we have, did we have any one that you recognize the name? We do have Joan Mitchell, Chris Ulmer, Sarah Romano. Those are 3 people that have joined us via Zoom that are not obviously a part of the board. That again, unless they're here with Mr. Henry, I would assume that they're here with Mr. Bailey.
Yes, my name is Joan Mitchell Hogan. I'm one of the owners of the property. I own the property with my daughter Mariah and my husband John. And I'm here with my attorney, Ryan Henry. And I don't know where my daughter having a disability came in. That's not true.
Okay.
Okay.
So
hold on, Ms. Mitchell. We're just going to get back with you in just a minute. I wanted to be sure that there's nobody here in addition to Mr. Bailey who wishes to speak in support of the appeal. And I've asked once, going twice.
You mentioned it. You mentioned it, Alma and Romano.
Yeah, Sarah Romano, and then we have a Chris Ulmer as well.
Okay. Either
But neither of them have unmuted, so.
Okay. Either Ms. Romano or Mr. Ulmer, if you do intend to speak, this is your opportunity. If you want to speak in support of the appeal, if you just want to watch, that's fine as well. I will note for the record that when we first heard this matter, we did have a number of people from the neighborhood who were opposed to the short-term rental and in support of the appeal. And furthermore, I note for the record, as Mr. Robert has pulled up here, that appears as though a vast majority of the neighbors do support the appeal as well. So
100%.
Okay. So we'll hearing nothing from
anyone. May we interrupt briefly?
Yes, please.
This is John Ulmer. My wife Chris is the one that's actually logged in there. I think it might be a little bit deceiving that there don't seem to be any people on the backing up Mr. Bailey's position. That might be happening because we weren't real clear how this Zoom meeting was going to go. I would just reiterate all of the positions and information that came across during the in-person public meeting. That I would bet that all of those people that gave that information then would very much like to have that information reiterated. And I'll just leave it there without trying to reiterate all of it. But it's not that there aren't any people paying attention. It's just I'm not sure this mechanism for putting the meeting together lends itself as well to that dynamic. And that's all.
Okay, Mr. Ulmer, I hear you. I appreciate that, and I'm confident that there are many people in the neighborhood who support this appeal. As Mr. Bailey says, all. So let's, if Ms. Romano wishes to speak, we'll hear from her. Otherwise, we'll move over to the owner. All right, let's hear from someone on behalf of the owner, Ms. Hogan. I don't know if you wanted to address these issues or if you have somebody else, your attorney, Mr. Henry, or okay, sure.
Yeah, I'm Ryan Henry here on behalf of the Hogans. I know this was tough to get all the board members together for this meeting, so I do appreciate it. We're okay with the virtual format. I was going to give you a summary of sort of where we are now, because I know there's been a lot of moving parts, but I don't want to be repeating myself. But I guess I'll start with Mr. Bailey's comment that it was a mistake to approve this addition. Well, the city's already admitted this was a mistake to approve it as originally drafted, but they halted work on construction to correct it so the addition was proper. And that was because originally it was an ADU. It had its own kitchen, which would then disqualify it from being single family residential, because there would be two, ADUs or two dwelling units on the property. So part of those revisions included removing the kitchen facility, which they did and was approved. So, this addition was properly done. And Mr. Hogan met with both the building and planning departments, who confirmed over a 4-hour meeting that the revised floor plans removing the stove was all that was required. City didn't object to the fact that there was no connection between the addition and the main structure. The only requirement was that the addition was attached. So, the building permit was properly approved. It was revised when it was incorrectly approved by a member of the city who is no longer working with the city. I don't know if we want to discuss. Did you guys get a copy of the memorandum I prepared regarding the covenant? I didn't see it addressed in the beginning.
Yes, I think I know the one that you're referring to. It is entitled Memorandum, and it is
That's it.
4 pages long, and it relates to the issue of the restrictive covenants.
Correct.
Okay. Yes, we have that in the record.
Okay. All right. Great. So I guess a short summary of the events. As Mr. Hogan and Mr. Bailey mentioned, the building permit was improperly approved. Bailey's then met with the building and zoning department, made the corrections necessary to make this a proper addition. The Hogans then listed the main portion of the building for rent on Zillow, which Mr. Bailey then filed a complaint, and the Hogans were summoned to livability court. They're found guilty of advertising in violation of the base zoning district, because they have to rent out the entire house. Otherwise, it's not considered single family residential. The judge and Jason Rowe, who was there on behalf of the city, confirmed that the addition can be short-term rented if the category 3 requirements are met. The Hogans and Jason Rowe then spoke in the hallway and said there's nothing preventing, short-term rental. The application was approved. I know there's some questions about the line that said the short-term rental shall not create the need for exterior alterations to any building for the purpose of maintaining such accessory use. Whether or not that disqualified this from being short-term rental since the addition was built. But as already mentioned by Mr. Summerfield, when the addition was originally built, it was never intended to be short-term rented. And Mr. Bailey himself, admitted at the last hearing that he was told by the Hogans the plan was to have Mariah live in the addition. So all the requirements of the SDR application were met. The addition was properly approved. The only thing left were the restrictive covenants. So during Mr. Bailey's original appeal, City Attorney Magali Creech reviewed those and said the following: there's no express prohibition against short-term rentals. The city does not participate in disputes concerning interpretation of covenants that are supplied with a court decision declaring that these covenants bar any short-term rentals. The city would deny the permit request. There was no court decision ever rendered. It was the city's position that they don't participate in the interpretation of covenants, and also there's no express prohibition against short-term rentals in those covenants. If the board would like to interpret the covenants, I don't know if that's on the table, I prepared a memorandum addressing that, with, citations to South Carolina court cases. And, I don't want to read out loud something you've already read, but I know Mr. Bailey may not have seen this. So,
Yeah, you just summarize it if you could.
yeah, so basically, if you want to seek a covenant, you have to show it either by express language or by plain and unmistakable implication that it applies to the property. It's not enough for the implication to be, reasonable. It has to be unmistakable. And it goes on to say, historically, restrictions on the use of property are disfavored. The law favors free and unrestricted use of property. Therefore, doubts and ambiguities are resolved in favor of free use and against restrictions. The determination of whether language is ambiguous is a question of law, and extrinsic evidence is not admissible to create ambiguities where they do not otherwise exist. The Supreme Court said, when interpreting a covenant, takes into consideration the evil it was designed to eliminate. Well, these are 1965 covenants. Short-term rentals were not around then. As Mr. Summerfield mentioned, the zoning code is in the process of being updated to sort of have a look-back period from when the building application was submitted and when the addition becomes used for short-term rentals, but that hasn't been done yet. And it specifically, I think we sort of already went over that Section 4 and Section 9. There's no language in there that expressly or through implication bars short-term rentals. The one section that Mr. Bailey and the neighbors seem to be relying on is that Section 8 that talks about no noxious or offensive trade or activity shall be carried on any lot, nor shall anything be done thereon which may be or become a nuisance or annoyance
Ryan,
to the
could you
neighborhood.
speak a little bit slower and closer to the microphone? I'm
Sure.
not catching all of this.
Can you hear me all right now? Just have these.
Yeah, just maybe if you just.
Is that better?
When you're reading from your memo, maybe you should go a little slower if you don't mind.
No problem. I was trying to get through it quickly because I figured y'all already read through this, but no problem. So there's actually a South Carolina court case that says people who live in organized communities must of necessity suffer some inconvenience and annoyance from their neighbors and must submit to annoyances consequent upon the reasonable use of property by others. Well, this property is zoned short-term rental category 3. I would say that's a reasonable use of their property to use their property as it's zoned. Importantly, 3 decades after that decision was made, later courts cited this decision and used the same language in a case involving planned residential development. In Lafergie, South Carolina case involving a planned golf community, a protective covenant provided that no noxious or offensive activity shall be carried on upon the property, nor shall anything be done thereon tending to cause embarrassment, discomfort, annoyance, or nuisance to the neighborhood. In Lafergie, the plaintiffs lived in a planned community of homes surrounding an 18-hole golf course operated by a defendant association. They claimed that a newly constructed golf course tee box adjacent to their home was a nuisance because of noise from conversations, golf carts in operation, and balls being hit. The court, citing Wingate, said, people living in organized communities must suffer some annoyance and inconvenience from each other incident to city life. The plaintiff noted the court shows property abutting a golf course and the limited golf-related activities occurring in a golf community to which they were subjected to not render the location of the tee box or the manner in which the course is being operated a common law nuisance subject to an injunction. So Lafergie makes it clear that Section 8 of the covenant should not be enforced because this identical covenant language has been interpreted to exclude annoyance. Here, the Category 3 STR use is allowed under the zoning ordinance. The neighbors chose to live in a neighborhood where Category 3 short-term rentals were permitted. And again, there's no language in Section 8 of the restrictive covenants or elsewhere that expressly prohibits short-term rental use, nor is there a clear and unmistakable implication of the same. Where therefore the language of Section 8 is equally capable of 2 or more different constructions, the one that least restricts the use of the property should be adopted, and the short-term rental use should be permitted. I'd also like to note that the neighbor complaints are mainly about noise and, having people in their neighborhood that they didn't want to be there and increased traffic. We're talking about a 720 square foot addition with 2 bedrooms in it. The majority of these are going to be people here for the weekend. I don't think they plan on spending their time in the farm field neighborhood. Probably unlikely they're bringing a car. If they do, I'd imagine 2 people are traveling together. We're talking about one more car in the neighborhood. They're not allowed to use the pool. You know, Mariah has to live next to these people in the same building. And there's nothing that prevents the Hogans from renting out this entire 6-bedroom house, you know, to a bunch of college kids and having 4, 5, 6 cars in the driveway and, you know, having a real issue. I mean, we're talking about short-term renting a 720 square foot addition, which their 25-year-old daughter will be living next door to. I just respectfully request that the board here follows the original recommendation of approving this application provided by the commissioner. Thank you.
Thank you, Mr. Henry. Let me ask you, what's your position on the permit application where they had checked the box that said, I think there were 3 options on the construction permit application with respect to short-term rental. And it was either, is there a short-term rental there in place? Or I can't remember the exact language.
I got it in front of me.
Yeah. Do you intend to have a short-term rental now or in the future? You know, there's three different options, right. and they selected the, you know, no, it is not, nor will it be short-term rental.
Sure. So it reads, does the building currently contain or will it contain a short-term rental unit? And the Hogans check no. And again, as Mr. Summerfield mentioned, the intent was always to have this addition be lived in by Mariah. They never intended on renting out this addition, whether long-term or short-term. And as Mr. Summerfield mentioned, you know, there's currently nothing in the zoning code that has any sort of a look-back provision where if you change your mind later or anything like that, and the zoning department is looking to revise the ordinance to address that. But as it's been interpreted and as it was explained to me by Jason Rowe, if you look at that email I sent you all, it's sort of similar logic that Jason spoke about regarding the requirement in the short-term rental application that no addition, or I can pull the language if you'd like, but you know, it's basically the same thing that says, you know, no exterior alterations are required in order to short-term rent this property. Well, it's Mr. Rowe's belief, which he confirms in our emails between the two of us, that the Hogans' intent was never to short-term rent this addition when they built this addition. So yes, they've changed their mind now because they found out that they cannot long-term rent the main portion of the home. So now they're looking to short-term rent the addition so that they can comply with the zoning code as it was explained to them. So yes, you know, they'll openly admit that yes, now they are short-term renting that, but their intent was never short-term rent when the building permit application was filled out.
Okay. And I would expect that they would say that if they had not received a summons from livability court, that they would have rented the property on a long-term basis. Is that right?
Right. Their plan was to have Mariah live in the addition and long-term rent out the main portion of the home. You know, there's nothing in the zoning code expressly that sort of deals with long-term rentals. You know, there's no application process or anything like that. So they just advertised it for rent. Were brought in and told, you know, you can't have.
And that was challenged, and the reason is because Mariah couldn't live as in an ADU without a kitchen. Is that what the problem was?
They'll be violating the single family requirement, being zoned SR1 if Mariah was in one and another family was in the main portion.
Okay.
And
but it meets all the other criteria of the Category 3 short-term rental.
It does. And if you look at the emails I sent with Jason Rowe, he's the one who confirms that in those emails that he reviewed the application and thought that it met all the requirements. And he says it in the transcript as well, that he'll have to review the requirements, but believes it meets the requirements. If you read the livability court transcript.
Yep, I read it. Yeah, I read it. Okay, do we have any other questions for Mr. Henry from board members?
I have a question. I'm wondering, did anyone ever live in the addition?
I believe Mariah and her older sister used to live there as well. I'll have to have the Hogans confirm that.
Actually, no, the addition is new. It was completed last July. And the only one that's lived in the addition is Mariah. That's it.
Thank you.
Anybody else have any questions for Mr. Henry? On the board? All right, so let's hear from anybody else on behalf of the owner. Ms. Logan, are you intending to speak, or anybody
Yes.
else on behalf of the owner? Okay,
Yeah.
we'll hear from you.
Okay. I would just like to say that we've done everything the city has told us to do, despite Jimmy Bailey constantly meddling in every step we've taken with our property. Also, remember, there's no HOA here. He shut down our already started construction in March of 2023, even though we did everything correctly. Our project was inadvertently approved as an ADU. Jimmy should have left well enough alone here. Once it was no longer an ADU, now the possibility opened to short-term rent the addition. We weren't looking to do that clearly, but when he shut down our job, we adjusted to remove the stove so the stop work order would be lifted and construction would be quickly resumed in the interest of time and having contractors scheduled. At the last hearing for our property, Mr. Bailey made an extensive presentation and in front of this board publicly gave credit to getting help with this appeal from quote unquote, someone you all know very well. That person is City Council member Ross Appel. An email with him is actually in the Jimmy Bailey appeal submission documents presented at our last appeal meeting. Since City Council appoints this very board, that is a serious conflict of interest and an ethics violation. He has helped Mr. Bailey twice against us, once in getting the construction shut down and again with this appeal. It seems to me that this board considering interpreting and applying restrictive covenants that city zoning officials and city legal counsel have already concluded do not apply is unfair. It's over 14 months since the addition was completed. Our house is arguably the nicest house on the block. We certainly have the largest capital investment made there. We've been dragged into livability court for advertising to long-term rent. Livability court judge Shahid suggested we apply for a short-term rental. It's been almost 5 months since the short-term rental has been approved and then appealed. This continues to cause us undue financial hardship and stress. We have been denied the right to utilize our property as we've been approved for. Thank you.
All right, thank you. And I see it says Joan Mitchell. Is it Mitchell or Logan? I'm sorry.
It's Mitchell Hogan.
Okay, all right, Ms. Hogan, thank you. Is there anybody else who wishes to speak on behalf of the property owner?
No.
Okay. Does anybody from the board have any questions for Ms. Hogan? All right, hearing no questions, then we will permit Mr. Bailey a brief rebuttal.
Mr. Bailey, you need to unmute.
Mr. Bailey, you're on mute. Yep, sorry.
Now can you hear me?
Yes, sir.
Let me just address a few things. When we saw, actually I was on the golf course and I got a text from a neighbor saying that a stop work order had been put on the house. I called the building inspector's office to find out why. And they said because they couldn't do what they wanted to do. And I said, well, why don't you tell them that? Not opposition. It's what the inspector's office said. So I called Mr. Hogan and I said, no, I didn't call him, excuse me, I texted him. And I said, you might better check with the city because what you want to do, that being to rent out long-term and Mariah live in a small place. I said, you might not be able to do that. I hate to see you spend a lot of money and not be able to do what you want to do. I wasn't the one that started that, regardless of what you just heard. But in any event, after that, you have the information in front of you, the emails between Lee Batchell and myself. And Lee said very plainly, it's got to be single family for both the main house and the addition. It can't be rented out. It's got to be one family and the whole thing, all 6 bedrooms. Now, so that's what Lee said. And then all this stuff about going to court and all that, you know, I didn't have anything to do with that. But again, when it came out of livability court, if you look at the emails from Lee to me, he said it had to be one family living in the whole property. Now, the ordinance says you can't build an addition in order to have a short-term rental. And I want you to use common sense. If you approve this application, you open a can of worms that will allow other people to say, well, we just want an addition, and then come back a year later and say, well, we've decided we want to put short-term rental. There's something wrong with that. And so I want you to also think about this. The new addition is 2 bedrooms, a living room, a dining room, a kitchen, and there's a solid wall between that and the main house, which is 4 bedrooms, living room, dining room, kitchen, whatever, 2 baths, I think. So if the short-term rental is in the new addition, that leaves 4 bedrooms in the main house. What's going to happen there? How many people are going to be in that? You go back to Lee Batchelor's emails to me, back and forth, says it's got to be one family living in the whole thing, single family. If that's not the case, then you need to rezone the property. And the property hadn't been rezoned. So that would be my message to you. Use common sense in this. The ordinance says you can't add an addition. If you allow this to happen, you open up a can of worms. State law says you got to pay attention to the restrictive covenants. And it just boggles my mind to think that the restrictive covenants are in place. No one has changed the restrictive covenants to say short-term rental can be or should be allowed or can be allowed. That's not happened. The restrictive covenants are still in place. So I admire your positions and what you're doing and giving your time to the city and to the community, but it's very clear to me that this property is owned single family and one family needs to live in the whole thing. Thank you very much.
All right, thank you, Mr. Bailey. Any board member have any more questions for Mr. Bailey? All right, we'll close the public session of the meeting, and we can discuss these issues. Robert, it's my understanding that the city's recommendation is to deny the appeal. Is that my understanding?
That's correct. It's our position that we have evaluated this in fairness to what the zoning code says, and that the short-term rental permit was not issued in error.
Okay. And what about Mr. Bailey's contention that you know, the permit originally shouldn't have ever been granted. They shouldn't have had the ability to construct that addition. Is that something that the city did in error, or is that something that was?
So I think as some of Lee's messaging implies, I think there's some additional questions that the staff member who, as mentioned, is no longer with the city, maybe should have asked during that process. But no, the addition with the changes that were made post the stop work order, removing the stove, which is what is the element that constitutes creating a second kitchen, which is where we get into the second dwelling unit, essentially. That addition was at that point then legal.
Okay, thank you, Robert. Does anybody with the board think that it would be a
I
good
move to
idea?
executive session, Mr. Chairman.
So there's a motion on.
Mr. Chairman, we have to amend the agenda to include an executive session. And I think Ms. Creech can correct me if I'm wrong, but I think that needs to be a 2/3 or 3/4 majority. It's some supermajority set up there, which I don't think will be a problem. And then we would move in, and then I'll need a few minutes to move our non-board / staff member participants into the waiting room. For those that are not a part of the board or staff, you would go into a waiting room. As soon as we're ready to come out of executive session, I'll bring you back into the meeting, just so that everybody knows you're not being kicked from the meeting. You're just being put into a waiting room until the board would come back in the session.
So, Mr. Summerfield, do we need a separate motion to amend the agenda?
That's my understanding, but Ms. Creech is here she's shaking her head yes. So I think we need a motion to amend the agenda to include an executive session. And then once we have that affirmative vote, then move into executive session.
All right, Mr. Morrison, you want to make the motion?
Yes, sir. Mr. Chairman, I move to amend the agenda to allow executive session.
Is there a second?
And I would add that we need to state the specific purpose for the executive session in the motion.
For legal advice from counsel for the city.
I'll second that motion.
All right, we got a motion to amend to add executive session to the agenda for the purpose of receiving legal advice. We have a second from Mr. Bennett. And so we'll just go ahead and vote. All in favor, please say aye. Aye.
Aye.
Aye.
Is there anyone opposed? No one's opposed. So, Ms. Creech, do we now need to move to enter executive session?
Yes, we need a motion to go into executive session to receive legal advice.
We'll need a second motion.
I move again that we go to executive session for legal
right.
advice.
All right, is there a second?
I'll second.
All right, Mr. Bennett seconds the motion to go into executive session. All in favor, please say aye. Aye.
Aye.
Any opposed? None are opposed. We'll move into executive session.
Give me 1 minute, and then Craig, can you stop the recording while we're in the executive session, please? And the live stream?
Yes, sir. Give me 1 second. I'll let you know when it's done.